Justice V. Kumar, a former judge of the Kerala High Court, and he was kind enough to accede to our request. And as usual, in his own style, he has given us 15 broad questions which will be taken up. And amongst us, we have Mr. S.K. Raj Menon and Shyam Padman and myself, who will be taking these questions in a seriatim. And Justice Ram Kumar, it's the other way around where he will be answering them. It's a rare chance where the lawyers can ask the question and the judges answering that. And be that as it may, before we request Mr. S.K. Prem Raj to introduce the topic and Justice Ram Kumar, I would request Mr. Shyam Padman to say something on how we should maintain the social distancing, keep on wearing the masks, because that is essential during these COVID times, and then Mr. Prem will take over.
What I can say, with the advancement of science, the distance between the stars, distance between other things has become very, very shorter. But as we go along, the distance between the souls are getting, extended, at least through these sort of platforms. Though social distancing is the norm as far as COVID virus is concerned, we have been connected inextricably, I'll say, because of this platforms like what we have back in Kerala, the Littles, wherein academic platform has been playing the role of bringing the north, south, east, west, everything. The national integration is through knowledge sharing. With these words, I'll request Prem to do the honors.
Well, now to introduce the topic and introduce Justice Ram Kumar, it's a very, very difficult process actually. Now today's topic I would first introduce. Today's topic is the test identification parade, which you call as TIP, which is a process by which the identity of persons or even of things which are related to an offense which is under investigation or even a trial could be established through a parade. And this test is used in the actual meaning of an examination in which the witness is to find out the person or the thing in that particular parade. It is held at the incept of the investigating agency, and it is having a twofold purpose. The first is that it is to enable the witness to satisfy themselves that the person or the thing whom they are suspecting is really the one which they have seen during the commission of the crime, that is at the scene of the occurrence. And secondly, it is to satisfy that the investigating authorities that the person whom or the thing whom they suspect is the one that the witness has actually seen. And this really strengthens the evidence of the prosecution, which corroborates the doc identification, which alone is the substantive evidence. And there are various procedures and precautions which are to be taken for its conduct, and which will be dealt with by Justice V. Ram Kumar during his talk. And there are exceptional procedures also. TIP could also be conducted by using photographs or sketch, and even by the voice of a suspect. Kindly imagine in case the identifying witness is blind. But of course, the evidentiary value of the voice identification, it may be fragile. It may be fragile unless it is supported by the other attendant circumstances. And we know that TIP needs to be, it has to be conducted as soon as possible after the arrest. Anyhow, delay does not matter also. And now you have section 54A of the CRPC, which provides for the identification, which has come to the statute book, I think during 2006, and its first proviso, I think during 2013, if my memory doesn't fail me. And we have a beautiful ruling by His Lordship Justice D.Y. Chandrachud for a 3-judge bench, Rajesh Elias Sarkaria's case, AR 2020 Supreme Court, 5561, in which he calls out the precedential principles of the TIP. And he says that it is governed by 162 CRPC and that it is relevant under section 9 of the IPC. And regarding the evidentiary value, this test identification period is having a very weak piece of evidence. And the weight of that evidence, that depends upon the reliability of the witness, and the value can vary depending upon the reliability of the witness. And now coming to the speaker, Justice V. Ram Kumar needs no introduction. Everyone among us knows him inside out. He is a great judge who always bore his trademark smile even during many watershed moments, which included even a contempt case, a politically motivated contempt case. And to be very frank, he is my hero judge. And with those words, I would start with the first question. Sir, can I?
Thank you, Shyam. Thank you, Prem. Now, my usual caveat and my usual articulation. Don't consider me as an expert. I am only a facilitator who is interested in sharing his knowledge and experience to you, and in the hope of learning a lot of law from you as well. Now, I personally feel that any theoretical law is better understood when applied to concrete fact situations. That explains these questions. Now, you can read the first question, Mr. Prem.
The first question is, the question of identification of an accused person falls under which among the following statutes? A, the Code of Criminal Procedure 1973, B, Identification of Prisoners Act of 1963, C, Indian Evidence Act of 1872, and D, Indian Penal Code of 1860.
Can any of the viewers venture an answer? Advocates?
Post in the chat also.
So they will be only posting on the chat because we have muted everyone.
Absolutely.
Oh, you are muted. You have silenced everyone. Okay. It is, there is a confusion. Some get confused that it, in view of the recent amendment to CRPC, some are confused that it falls under the Criminal Procedure Code, Code of Criminal Procedure. No, it falls under the Indian Evidence Act. Indian Evidence Act is the question of identification falls under the Indian Evidence Act. Now, second question.
Sir, which provision of the above law governs the test identification parade? Now that you have said that it's Indian Evidence Act, yeah, there's a lot of postings coming in, sir. Section 9 is being identified.
Yes, correct. Yeah, they are absolutely right. Section 9 of the Indian Evidence Act is the provision which governs test identification period, TIP. Then pass on to question number 3.
Sir, which aspect of the above section covers test identification parade? Should I read the section?
Okay, no problem.
Facts necessary to explain or introduce relevant facts. Facts necessary to explain or introduce a fact in issue or relevant fact, or which support or rebut an inference suggested by a fact in issue or relevant fact, or which establish the identity of anything or person whose identity is...
Please emphasize that. Facts which establish the identity of anything or person. This aspect of Section 9 is covered by TIP, Test Identification Period. Yes.
Sir, this third question is also done.
Yes.
Fourth I will take. What are the usual modes of fixing?
Yes, please.
Because second and third were intermingled. What are the usual modes of fixing the identity of the persons?
Yes. As rightly suggested by Mr. Prem Raj, usual modes of identity are sight. One is sight. Test identification period is sight, identification by sight. Then comes smell. For identifying a person through smell, the police very often engage the sniffer dog. And then fingerprints, by comparing the chance prints with the specimen fingerprints. An expert may be able to say that these fingerprints belong to the accused or somebody else. Then footprints. Footprints, of course, though don't have that much accuracy as fingerprints, but still footprints are also used for comparison. Then comes hair, by comparison of chance hair strands with specimen hair strands by means of visual microscopic examination, and then subjecting the strands to microtome evaluation by determining the medullary index of the hair strand. Then comes the through personal belongings like ornaments, wristwatch, handbag, etc. And in one decision of the Supreme Court, they said women have a particular uncanny knack of identifying their personal belongings, like ornaments, etc. This is attributed only to women, not to men. Then skull by the superimposition technique. Skull identification of a person through superimposition technique of the skull. Then voice. Mr. Premraj already referred to that voice. That is by voice analysis. Then DNA profiling by comparison of the crime exhibits with properly collected samples of cells, usually through blood. Then comes the blood sampling, blood comparison of the blood group, blood, etc. These are the usual modes which fall under section 9 for identifying persons or things. Yes, we now pass on to question number 5.
The next question, can I just put one question? That is,
yes.
In certain movies we used to see that a person is differentially abled. Prem was alluding to that. He is blind, but he can definitely identify the sound spoken to at the crime scene, or he identified the smell. Other than the sniffer dog, can human beings can also be? Is it relevant? His evidence. He says that
the olfactory, the olfactory capacity of human beings to identify persons has not been at least employed in crime detection, because sniffer dog is the best person for that. But there also Supreme Court has observed that that evidence is very frail, because you can't put the sniffer dog in the box and cross-examine the dog. He is not available for cross-examination. Therefore, it is a very frail nature. But then these are all techniques which instruct the investigating agency to know for himself that he is proceeding on proper lines. He is proceeding in the right direction. It is only for that. They don't constitute substantive evidence. They only corroborate the substantive evidence subsequently given in court. Yes.
Right.
Question number 5.
In fact, this question that was considered by the Supreme Court in the Gola Govinda Pradhan's case was the state of Orissa, and even an identification from the voice or from the smell, it can be possible if there is evidence to show that the witness was sufficiently acquainted with the accused in order to recognize him by his or her voice or smell. But that evidentiary value is very fragile.
Absolutely.
Even handwriting also similar. Person conversant with the handwriting of a person, he alone can say, oh yes, this is his signature, this is his handwriting. Even he can be duped. Such a person can be duped.
Section 9 is widely worded in the sense like, if you are able to substantiate in a court of law, well and good.
Yes. Now, question number 5.
What is the purpose and relevance of test identification query?
Yes, Prem had already mentioned that. I will go to a constitution bench ruling of the Supreme Court in Harnath Singh versus State of Madhya Pradesh, AIR 1970 Supreme Court 1619, where these observations are very apposite. During the investigation of a crime, the police has to hold identification parades for the purpose of enabling witnesses to identify the properties which are the subject matter of the offense, or to identify the persons who are concerned therein. They have thus a twofold object. First, to satisfy the investigating authorities that a certain person not previously known to the witnesses was involved in the commission of crime, or a particular property was the subject matter of crime. It is also designed to furnish evidence to corroborate the testimony which the witness concerned tenders before the court. Therefore, test identification parade is always resorted to only in those cases where a witness concedes that he has no previous acquaintance with the assailant or the accused. Supposing the witness was seeing the accused, or the victim was seeing the accused for the first time at the time of occurrence, then that may be a situation where the investigating officer has to be doubly sure that he is proceeding on the proper lines. Therefore, he resorts to the test identification parade so that the witness can give him more inputs about the person he is trying to identify.
Sir, on account of the proliferation of the social media, could this not be defeated by giving publicity regarding one photo, showing him as the person or possible culprit, so that could it not
that
be defeated?
that is the possible danger. That is the danger to a successful TIP. Even in media, forget about social media. There are instances where the police officers, without covering the face, masking the accused, parade them through the road, and the media covering them. Papers may carry the photographs, and maybe next day the accused may have to undergo a test identification parade, and the witnesses who are to identify will have no difficulty to identify him because they have already seen him in the social and other media. That is one danger to this system. Anyway, it can't be, you can't escape. Yes.
The question number 6. The investigating officer conducts an investigation parade. During the investigation...
One second. Before that, there's one decision which I want to bring to your notice. That is the decision by Justice Anna Chandi way back in 1960. 1960, KLT 965, Chellappan Nair versus State of Kerala, where the learned judge had made this articulation. Human memory is fallible and it plays lot of tricks with us after the lapse of considerable time when we attempt to remember strange persons whom we saw for the first time, and that too for a short while. So the evidence given by the witnesses from the witness box becomes trustworthy only when it is corroborated by a test identification parade conducted by a magistrate at the investigation stage. In cases of this nature, test identification parade of the suspects ought to be held at the earliest opportunity possible before a magistrate. Beautiful statement of law by Justice Anna Chandi, who was probably the first woman judge, High Court judge in India. Yes, question number 6.
Yeah, Premji. Oh, Shamji.
Your turn, Sham.
Okay, I will read it then. The investigating officer conducts an identification parade during the investigation and relies on the same during the trial of the case. The written proceedings prepared by the investigating officer shows that the identification parade was conducted by the IO in a fair manner, giving no room for attacking the procedure, and that the victims had correctly identified the accused persons. Can you not treat the evidence of the IO as a corroborative piece of evidence?
He is an investigating officer. If he can investigate a cognizable offense, even like murder or rape, why not trust to the investigating officer? He can conduct it foolproof in a fair manner. That is what he did in this case. But then, when he gets the confirmation regarding the identity, etc., either through signs or by words, what is it that is he doing? He is getting a confirmation. He is the investigating officer. It will be a statement falling under section 161 and hit by section 162. In fact, way back in 1940, a division bench of the Madras High Court in Guruswamy Thevan versus Emperor, 1936 MW1 Criminal 25, held that the act of a witness identifying a suspect to a police officer is not a statement, and therefore it will not attract the ban under section 162 CRPC. This decision was specifically overruled by the Supreme Court in Ramkishan Mithan Lal Sharma versus State of Bombay, AIR 1955 Supreme Court 104, wherein a different view taken by the Calcutta High Court in AIR 1943 Calcutta 644, a three-judge bench 44 was upheld, and this Madras view was overruled, and the Supreme Court said no, when a witness identifies the suspect to an investigating officer, howsoever in a fair manner he conducts it, it is hit by section 1, the interdict under section 162 CRPC. There's a beautiful judgment recently in 2017, Murugasamy versus State, represented by Inspector of Police Coimbatore, and that is 2017 5 CTC 561, rendered by the Chief Justice Madras High Court and P.N. Prakash. Justice P.N. Prakash is the author of the judgment. Beautiful judgment. They have given all the historical background of TI parade and the way in which Madras High Court decision 36 Madras was overruled by the Supreme Court, etc. But every one of you should read that decision. I can give you the CTC also. 2017 5 CTC 561. Investigating officer cannot bypass the process of test identification parade through the magistracy and cannot themselves undertake identification process. When the police show the accused to a witness and ask the witness whether he can identify the accused, the answers given by the witness or even by the accused at that time will be hit by section 162 CRPC. Earlier in the judgment which I referred to by Justice Anna Chandi, the learned judge had taken the same view. Chellappan Nair versus State of Kerala, 60 KLT 965. Then there is a beautiful decision by Justice U.L. Butt and T.V. Ramakrishnan, authored by Justice U.L. Butt. Unfortunately, the full text of the judgment is not available. 1989 2 KLT short notes to case number 3. Beautiful judgment. In fact, KLT and many of the law journals have the nasty habit of not reporting long judgments. Long judgments they don't report. They will only give it in short note. In this case, even the name of the parties are not given. Names of the parties are not given. See what KLT did? Okay. Question number 7.
What Prem has asked, the next question would be, if investigating police officer cannot conduct a test identification parade, who else can conduct the test identification parade, executive or judicial magistrate?
Yes, there is some confusion as to whether an executive magistrate can conduct TI parade. TI test identification parade itself is a judge-made law. The TIPs are conducted under the supervision of the executive and judicial magistrates. In fact, in Yaqub Abdul Razak Memon versus State of Maharashtra, 2013, Volume 13 SEC, page 1, a special executive magistrate conducted the TIP. Likewise, in Raja versus State of Karnataka, AR 2016, Supreme Court 4930, a Tahsildar conducted the Tahsildar of Bangalore North conducted the TIP in that case. So executive magistrates also can conduct TIP. Only thing is they have to do it in a foolproof and fair manner, because this function cannot be entrusted to the police for the reason already stated. Whatever they do will be hit by section 162 CRPC. And the judiciary, by and large, do not believe the police in proper conduct of TIP. Yes. Then until the year 2006, when the two amendments were, the two sections which Mr. Prem mentioned, that is 254, section 54A and section 291A, which were introduced by with effect from 2006, came into force. The procedure both in Kerala and Tamil Nadu, I do not know about the other states, was that for the conduct of test identification parade, the police will move, the investigating police will move the chief judicial magistrate and request the chief judicial magistrate to requisition the services of a judicial magistrate. CJM will requisition the services of a judicial magistrate other than the jurisdictional magistrate for conducting the TI parade. That was the procedure. Now, after the insertion of section 54A to the CRPC, the jurisdictional magistrate himself, when moved by the investigating police officer, can direct the accused to undergo a TIP in the manner to be suggested by the jurisdictional magistrate. Of course, he will not conduct it. He can direct he can either request the chief judicial magistrate or any other magistrate to conduct it, so that now the police need not go to the chief judicial magistrate directly and get a circumlocutory way of getting a magistrate for TIP. That procedure is, but unfortunately, 54A only recognizes executive magistrate. Judicial magistrates are not, except when the person identified is mentally or physically disabled. In a case where mentally or physically, the identifying witness is either mentally or physically disabled, then the proviso to section 54A, the TIP shall be conducted by a judicial magistrate. In all other cases can be by executive magistrate. That is the new section 291A renders a document purporting to be the report of identification under the hand of the executive magistrate exempts him from being called as a witness. But such a benefit is not given to a judicial magistrate. That is according to me, the failure of the legislature. They could have included the judicial magistrate also, so that here, if and when the parties want the judicial magistrate or executive magistrate to be made available for cross-examination, they can summon. Otherwise, his report as such can be accepted by the court. We do it in the civil cases, under Order 26, Rule 10, is it not? The commission report, etc.
Right, right.
Yes.
Yes, sir. A and
Yes,
B
question
are,
number 8.
what is the procedure to be followed while conducting a test identification?
This is one on certain aspects on which there is a lot of confusion. In fact, we in Kerala are following the Madras procedure, Madras practice. It's all covered by directions issued by the High Court and in the form of police orders. The procedure is what the magistrate should do. In fact, I can read some of the procedures. The selection for the parade of non-suspects of the same should be of the same religion, status, and who are unknown to the witnesses. Nowadays, I don't think persons of the same, because you can't employ policemen as non-suspects to be paraded along with the suspects. Therefore, the usual scenario or usual venue for conducting TI parade is the jail, prison, where prisoners are being mixed along with suspects as TI parade. And as per the Madras High Court procedure, at least 9 non-suspects should be mixed with a suspect, and they should be so dressed up as to look like the suspect, or should be looking almost identical, so that there will be some confusion. In spite of that confusion, if the witness is able to identify the assailant, then the TI parade can be said to have successfully conducted. Then wherever possible, privacy should be secured for the parade, away from public view. Then the names of total number of men assembled for the parade, including both suspects and non-suspects, should be recorded by the magistrate. It is desirable to exclude police officers. This was fixed long back. It was considered desirable. And nowadays they are never included. Consistent with the safeguards against escape of prisoners in custody. If jail officials are present at the parade, they should be kept in the view of the magistrate all the time, and they should not be allowed to access either to the witnesses who have to be summoned for identification or to the persons assembled at the parade. The witnesses who have been summoned for the parade should be kept out of the view of the parade. Each witness should be fetched by a peon separately, and after his participation in the parade, that his identification is over, that witness should be segregated from the others, so who have yet to be summoned. So one witness who has already identified the suspect, either identified or not identified, he has to be segregated. He should not be allowed to mix with the other witnesses to be summoned for identification, because for fear of information being passed on. It is the identification over that witness should be segregated from the others to have who have yet to be summoned. This precaution should exclude the possibility of signals or prearranged movements. It is desirable to change the order in which suspects have been placed at the parade before the arrival of the next witness. Supposing 9 witnesses are paraded, the person standing third from the left is the suspect. Others are non-suspect. Then after one witness identification process is over, before calling the next witness, you change the order, so that even if some signals or message is conveyed, that can go wrong. It is desirable to change the order in which suspects have to be placed before the arrival of the next witness. The peon deputed to fetch each witness should be kept out of the view of the parade and proceedings. Police personnel should not be used for this purpose. So every witness is summoned through a peon of the magistrate, and after that the peon is segregated, so that he does not mix with the others and pass on some useful information to the next witnesses. Before a witness is called upon to identify the suspect, the witness should be asked whether he admits prior acquaintance with any suspect whom he proposes to identify, and that fact should be recorded, because test identification is conducted only in cases where the witness did not have any previous acquaintance with the assailant. But supposing the witness witness admits to the magistrate, I know this person, I know him, though I don't know him by the name, I know him, he's residing near my house, he's my neighbor, so such thing, then that will have to be recorded by the magistrate. Any objection by any suspect to any point in the proceedings should be recorded. Supposing the accused says, one of the suspects says there's some unfairness in the proceedings, he can say that, he can tell the magistrate will have to record that. If this is recorded by a police officer, it will be hit by 162, mind you. That is why police investigating officers are excluded from TI parade. Where a subject wears any conspicuous garment, the magistrate conducting the parade should, if possible, either arrange or similar wear to others or induce the suspected person to remove the conspicuous garment. There are some accused persons deliberately wear some, either he grows a beard or he wears some special garment, so that it may be, he may be thinking that he is so special, but that may help the witness to identify him. Therefore, either the magistrate will have to ask the non-suspects also to wear similar garments, or the magistrate will have to ask him to remove that garment, special garment which he is wearing, to note detection, special detection. There are a volley of rules prescribed by the wise judges and passed on to the police manual, so that it can be done foolproof and in a fair manner. This is the procedure to be followed by every magistrate. Now, after the amendment of Rule 54, insertion of 54A, Section 54A, etc., now the trial magistrate or trial court itself can direct the accused to undergo, the arrested accused to undergo TI parade, and the procedure also the court can prescribe. But I hope that they will not prescribe a non-magistrate to conduct the TI parade, because the procedure is not, the modalities are not laid down in Section 54A. But reading Section 291A, it is clear that they had in mind only the executive magistrate, not even the judicial magistrate. Yes.
Now, before going to
and so you may note some rulings on this point regarding the manner of conducting TI parade, how fair it should be, how foolproof it should be. 1989 2 KLT short notes 2, case number 3, which I already referred to, Justice UL Butt and TV Ramakrishnan, authored by Justice UL Butt. That's a beautiful decision, but unfortunately full text is not available. We have only the short notes. Then Chandar Singh versus State of UP, AR 1973, Supreme Court, 1200, 3 judges. There, where the accused was a bearded man with a tape in neck. The 5 other persons who were paraded were not similarly bearded, and the TIP was therefore held to be a farce. Again, AR 1973 Supreme Court 337 is another decision, where also there was no homogeneous mix of the suspects and non-suspects. In fact, after the judgment of the division bench in Murugasamy case by the division bench, authored by Justice P.N. Prakash, all central prisons in Tamil Nadu have a special TI parade room with one-sided visible glass partition, so that the witness can see the accused, but the accused cannot see the witness. Yes. Question number 9.
Before we go to question number 9, regarding this procedure which is to be followed in conducting a TIP, it has been beautifully explained.
No, that is A and B.
No, before we go to question 9, question 8, which
okay.
we did
Okay.
beautiful ruling by Justice Ram Kumar along with Justice Padmanabhan Nair in the Jayakrishnan Master murder case, which of course was partly reversed later, but not on this aspect. And the citation is 2005, volume 3, KLT 1075. That deals with almost, I think, 9 or 10 procedures are laid down in that particular thing. And going to the 9th question, sir.
Yes.
A and B
Yes.
are the only two eyewitnesses to an occurrence. Both of them had no previous acquaintance with the accused. Both of them had only a fleeting glimpse of the accused, whom they were seeing for the first time during the occurrence. The fate of the case hinges upon their identification of the accused. When A was examined before the court, he correctly identified the accused, but he was unable to identify the accused during the TI period. B was given up by the prosecution, but the magistrate who conducted the TI period was examined by the prosecution. The magistrate, with reference to the memorandum which he had prepared at the time of the TIP, gave evidence to the effect that B was able to correctly identify the accused during the test identification period. If the court were to acquit the accused, is it justifiable? If so, give reasons.
See, this question and the next question will give you the full substance of the principle of test identification period. The relevance, the substantive nature and the corroborative nature of test identification period and the substantive nature of the evidence given in doc in the court. See, this is a case where both A and B are two witnesses who are eyewitnesses to the occurrence. Both of them had seen the.
Do we take the 10th question also then? If you are saying both, the answer would be together. So I think we can.
Not necessary. Not necessary.
Okay.
No. The answer to this may not apply to the answer to the next.
No, I said you are saying that the answer would be over.
Once you understand both these problems, the principle of test identification period, the nature of their evidence, the admissibility, evidentiary value, probative worth, etc., will be clear. This is a case where there were two eyewitnesses, A and B. Now, both did not have any previous acquaintance with the accused. Both of them were seeing the accused for the first time at the time of occurrence. They had only a fleeting glimpse. That's only a very casual glimpse of the accused. That is insufficient for them to remember the features of the accused assailants. Now, during the trial, A correctly identified the accused in doc. Doc identification in court is the substantive evidence. Identification in court is the substantive evidence. He correctly identified. In the case of B, prosecution had given up B, but the magistrate, in the case of A, even though he correctly identified the assailants in court without any hesitation, during test identification period, he was not able to correctly identify. The magistrate who conducted the TIP brought his memorandum and he said that A was unable to identify the assailant. But mind you, the substantive evidence is the evidence in court. Then in the case of B, prosecution gave up B. But magistrate who conducted the TIP very credibly deposed with reference to his memorandum that B had correctly identified the assailant during TI period. This is the evidence before the court. The magistrate, supposing he acquit the accused, both the accused, can you find fault with him? This question was devised by me for the sake of judicial officers in the Kerala Judicial Academy. This question and the next question. They will give you the in and out of TI parade. Now, this is a case where A's identification in court is absolutely worthless because when his memory was fresh, his memory was fresh, he could not identify the accused during TI period. TI period is conducted during investigation. He was unable to identify. In the case of B, there is no substantive evidence. He has not mounted the witness box. We have only the hearsay testimony of the magistrate who conducted the TI parade by saying that he correctly identified. So this is a case where court will be justified in acquitting the accused because for want of substantive evidence. You got the principle? If all of you got the principle, we will pass on to the next question.
The next question is also an illustrative one. At about 9:30
Yes.
while the housewife and her daughter are watching the TV in the house, the two accused persons gained entry into the house through the back door and suddenly pounced upon the mother and daughter. They threatened the mother and daughter with dire consequences if they raised any alarm. The accused asked the mother and daughter to remove the ornaments and hand it over to them. When they refused, they were tied down to a pillar and their mouth was gagged. The accused then forcibly snatched the jewelry worn by the mother and daughter. They threatened the mother and daughter to kill them in case they complained to the police. The accused were total strangers to the mother and daughter who had no previous acquaintance at all with the accused. Pursuant to the FIR registered at the instance of the mother, the police commenced investigation, arrested the accused persons and charge sheeted them. No test identification parade was conducted by the police. Both the mother and daughter during trial correctly identified the accused. It is argued by the defense that their doc identification of the accused for the first time is absolutely valueless. If the court were to
yes. Now, in the former question, I forgot to give you the citation. There's a case which went from Kerala, Kannan versus State of Kerala, year 1979, Supreme Court 1127, where the Supreme Court held that doc identification for the first time in court without there being any correct test identification parade by a witness who had no previous acquaintance with the accused is absolutely valueless. Absolutely valueless. That is why A, who had no previous acquaintance and who, though correctly identified in court, was not able to correctly identify the accused when the memory was fresh during TI period. In the case of B, there is not even substantive evidence in the form of evidence before court. Likewise, here also both the mother and daughter had no previous acquaintance with the assailants. And no TI period was conducted by the police, in spite of the fact that they had no previous acquaintance with the assailants. The question is whether a conviction can be safely recorded. This is an exception to the earlier principle that if earlier case they had only a fleeting glimpse, a lightning glance of the assailants, so that they could not remember the identifying features. But this is not such a case. Here both the mother and daughter had sufficient exposure to the features of the accused because they asked them to remove their ornaments. They refused. Then they were tied down to a pillar. Then their mouths were gagged. All this time they were watching the assailants. So they had sufficient opportunity to interact with the assailants. Therefore, notwithstanding the fact that they had no previous acquaintance with the accused, since they had sufficient interaction and sufficient exposure and opportunity to study their features, that makes all the difference. Therefore, even though the police did not conduct a test identification parade, the identification of these assailants by the mother and daughter in court can be given full credit. That is, you may refer to Ronnie alias Ronald James Alvarez versus State of Maharashtra, year 1998 Supreme Court 1251. Again, Damu, State of Maharashtra versus Damu, year 2000 Supreme Court 1691. Again, in that Shraddhananda's case, Swami Shraddhananda alias Murli Manohar Mishra versus State of Karnataka, year 2007 Supreme Court 2531. If the assailant, if the witnesses or the victims had sufficient interaction with the accused in such a manner that they had sufficient exposure to the features of the assailants, then the fact that no TI parade was conducted is of no consequence. So these two questions will give you the substance of the identification under section 9. In fact, one recent decision of the Supreme Court in year 2020 Supreme Court 556 year 2020 Supreme Court 254 Raja versus State by Inspector of Police. There by Uday U. Lalit, they say that even if the witnesses are not able to say the identifying features of the assailants, that's of no consequence. It is not necessary that they should either mention in the FIR or in the earlier 161 statement that these are the features. Then only a TI parade can be successfully conducted. No, even if they don't say that, the TI parade conducted will be unassailable. In fact, when Mr. Prem gave me a 2020 citation, I thought that this was the citation you were referring to, but that was something else. It's not.
That is a thesis by D.Y. Chandrachud.
Yes.
There again, the exclusivity of seeing these two persons alone in the dock will it not reduce the credibility than the other one? Because
No,
you correct.
see, this is only corroborative evidence, mind you. The identification in court is substantive evidence, but the test identification parade is only corroborative evidence. When the witness correctly identifies the assailants in court, then it corroborates their earlier test identification during TIP. But then, supposing they were not able to identify during TIP, which happened in Kannan versus State of Kerala, their identification for the first time in court, without there being a proper test identification, correct test identification, will be absolutely valueless. There are other rulings of Supreme Court also taking the same view. For DOCA identification for the first time, of course, mind you, this is all subject to these riders. The witness should not have any previous acquaintance with the accused prior to the occurrence. Accused should be a stranger on the date of occurrence. And no TI parade was conducted. And witness is identifying for the first time in court. That may be. Otherwise, of course, that danger is always there, Mr. Sham. When there are two accused,
They are able to mingle with the crowd. Instead, they are placed in a separate place as accused. So,
yes, yes.
what is the point identified?
That is there. That is there. Even otherwise, there are instances where policemen, in fact, supposing there are two accused present, the witness may not be knowing. Supposing he is a false witness, he may not be knowing who is A1, who is A2, and what are the acts done by A1, what are the acts done by A2. In such case, also police may tutor him. There is some. I am getting some echo, Mr. Vigas. The police may tutor him, and he may, as tutored by the police, he may correctly identify A1 and A2. All these dangers are there.
Correct.
Yes.
Because it's this.
Question 11.
Sir, is not evidence of test identification parade a piece of substantive evidence?
Yes, we already answered that. Test identification parade is never a piece of substantive evidence. It's only a corroborative piece of evidence. Substantive evidence is the evidence of the witness given in court while giving evidence during trial. So you may refer to a year 1994 Supreme Court 2420 Suresh Chandra Bahari versus State of Bihar, which decision is also important in the case of Section 27 recovery, where the Supreme Court held that no public witness need be there for 27 recovery. There's a wrong notion among the policemen and also among the lawyer community and judges also, that unless there are at least two witnesses to witness the Section 27 recovery, it cannot be proved. Because we all know that Section 27 is in the Evidence Act. It's a proviso to Sections 25 and 26. The law does not say that there should be independent witnesses. It is all made by the investigating officer as a contemporaneous document, so that he might have conducted so many investigations during his lifetime, during his career. So it may not be humanly possible for any officer to recollect the facts of each and every case investigated by him. Therefore, to have credibility, to place the facts on record, he may have a contemporaneous mahasar or panchanama. That is not the requirement of law. It's only a contemporaneous document to show what all things he did. So that when after days or even weeks or months or years, he is testifying before court, he can refresh his memory by looking into the Panchanama or the case diary. This 94 Supreme Court decision is also relevant in that aspect. Then AR 1999 Supreme Court 3916, that it is what is substantive evidence is the evidence in court, not TIP. TIP is only corroborative piece. AR 1996 Supreme Court 2511 to AR 2007 Supreme Court 676. There are any number of decisions, including the decision which Mr. Prem Raj referred to. Yes, question number 12.
Question number 12 is that the police failed to conduct the TIP in spite of a demand by the accused, even though the accused was already known to the eyewitnesses, including the victim. Is not the failure by the police failure?
First and foremost, the accused does not have any right to dictate terms to the investigating agency. He has no right to be heard. He has no right of audience during investigation. Even in the matter of change of investigating agency, he has no right to be heard because he is yet to be summoned. That is why in 200 examination, we noted the other day, when the sworn statement of the accused and the witness of the complainant and the witnesses are being recorded, even if the accused happens to be present in court, he has no right to participate in the proceedings because he is yet to be summoned. Likewise, during investigation, he is not summoned. Therefore, he cannot participate. He cannot dictate terms to the investigating officer. Therefore, even if the accused wants a DIP to be conducted, investigating officer need not conduct it if he is otherwise satisfied that the witness had sufficient exposure to the features of the accused. So the accused, they had previous acquaintance prior to the occurrence. AR 1998 Supreme Court 192. AR 1998 Supreme Court 192. Again, AR 2002 Supreme Court 2787. 2787. Question 13.
My question is a natural corollary of what this frame asks. I will put in this manner: a doctrine of self-incrimination, everything might be included. Can an adverse inference be drawn against the accused for his refusal to submit to test identification parade? I refuse.
Why? Why should he fight shy? Why should he fight shy to a TIP being conducted? If he is not the assailant, if he is not the culprit, the witness will not identify him. Why should he fight shy? That shows he has something to hide. He has got something to hide. Therefore, in a case where he unjustifiably refuses to undergo TIP, court may be justified in drawing an adverse inference against him. Manu Sharma versus State. But
right to remain silent. It's raining heavily. That's
yes.
why the background sound. The right to remain silent is available to the accused. Can it be connected with this one?
He can be silent. For TIP, he need only silently stand there. He need only silently stand there. It does not violate his right to silence.
So, but Manu Sharma was considered in the latest judgment of Justice D.Y. Chandrachud. It's a 3-judge case.
Okay.
That
yes,
is
yes.
Rajesh Sarkari versus State of Haryana. AR 2020 Supreme Court 5. It is 5561. The Supreme Court goes on to say that the finding of guilt that cannot be based solely on the refusal of the accused to undergo that TIP. He can refuse.
Yes, certainly. See, adverse inference is not for finding him guilty. That may be one of the circumstances which the court may consider, take into account for while convicting the accused. Supposing there are other adverse circumstances against him, this circumstance also may point towards his guilt. Why did he fight shy and refuse to undergo TIP? That's all. Merely from refusal, like abscondence, as in the case of abscondence. Abscondence is not a ground for straightaway convicting him. Abscondence may be one of the circumstances after the occurrence of an accused person absconding. That may be one of the circumstances which may go towards finding him guilty. But that is not the sole circumstance. Yes, AR 2010 Supreme Court 2352. 2352. Question number 14.
There again immediate contact after the occurrence, that is the absconding.
Of course. So I may have a fear. I may engender a fear that unnecessarily police are going to, because I was the only person here. So police may unnecessarily harass me. So I leave the place. Or a person who is having witnessed a crime, a dastardly crime, a heinous crime committed in front of him, he may vanish. That is what the Supreme Court Justice Chinnapreddy had articulated. I think it is 1984 Supreme Court or so. That which is that citation. Prem may be knowing. Some stay rooted. Some stay rooted to this at the spot. Some become speechless. Some seeing a ghastly crime being committed. Some stay rooted to the spot. Some remain speechless. Some slowly skulks away from that scene and goes as far as possible or some even counter attack. Some go to the rescue of the victim. Some even go and not only rescue the victim, may even counter attack the assailant. These are all observations made by Chinnaparadi. I don't remember the citation.
I think it's
Somewhere
80. Is it Sony versus
could be 80s. No, not Sony. Ram. I don't remember the citation right now. Beautiful observation. Again, I think in the same decision, Justice Chinnaparadi said, if murder takes place in a brothel, prostitutes are the most natural witnesses. If murder takes place in a residential house, inmates of the house are the most natural witnesses. You can't dub them as unnatural or interested witnesses. Likewise, if murder takes place on a public road, passers-by, they may be chance witnesses. Passers-by are the most natural witnesses. Beautiful exposition of the law by Justice Chinnaparadi. Same decision. I don't. I think 84 or so. I don't know. Or 9. I don't remember. Yes. Question 14.
Yeah. In a case where other persons with the same striking features as those of the accused were not mixed up during the test identification period, can it be said that the identification of the accused is unreliable?
It was held to be unreliable and unfair. I have already given the citation. AR 1973 Supreme Court 1200. Again, AR 1973 Supreme Court 337. Some particular features of the accused, of the suspect, should be there, should be at least planted in the case of non-suspects also, so that all look alike, creating a confusion in the mind of the witness. But I still don't understand why confuse the witness.
Or,
because
sir,
witness.
We have a round of persons arraigned who has got nothing to do with the crime at all. None of the accused. All
Yes.
100% different persons.
That is what is happening in TI parade. 9 persons who had nothing to do with the crime are paraded along with the sole accused.
We'll have 2 rounds. First round, nobody was connected with the crime, and the witness will be compelled to at least identify one. So,
No, there is no compulsion. No compulsion. Witness is merely asked, please find out whether the culprit is there among these 10 persons. That's all. Yes, question 15, the last question. It is a very long question. All because it's all covered by a decided case of the High Court of Kerala. So it's a long question, but very interesting question. Very interesting question of law also. Who will read that?
We are heading towards the evening, so we will ask Sham to read it.
Me. Oh my God. I thought Ray will be doing it. Fine. Okay, I'll do a 11-year-old boy was employed as a domestic servant by a government nurse. One day, a gold necklace of the nurse was found missing. Suspecting the boy, she took him to the police station and reported the matter. She went back to her house, leaving the boy at the mercy of the police. After some time, a detailed search in the house, the necklace was found out. The nurse went back to the police station and conveyed the said information. The boy was released to her custody. But by then, the boy had been brutally tortured by 4 police constables while the boy was in the police station. On coming to know of the incident, the boy's mother came and took him first to the hospital and then to the judicial magistrate. The magistrate took cognizance of the offences revealed. The boy told the magistrate that he can identify the 4 policemen by their face and he does not know the names except one whose name was referred to by the companion policeman. A petition was filed on behalf of the complainant to conduct a test identification parade before the memory of the boy fades. The magistrate allowed the petition and got the concurrence of the Chief Judicial Magistrate also. After ascertaining the names of the policemen who were on duty on the fateful day, the magistrate asked 15 of them to appear before him for a test identification parade on a specified date. One of the said policemen challenges the said order before the High Court under Section 482 CRPC. Will he succeed?
See, a 11-year-old boy, he was employed by a nurse. A necklace was found missing. Boy was suspected. He was taken to the police station. Matter was reported. Then she had, probably the policeman might have advised her to make a further search. Then leaving the boy there, the nurse went home. She made a further search and the necklace was found out. Then she returned and reported the matter. Boy was released to her. She found that the boy had been brutally manhandled by 4 police constables while he was in the station. Then the next day, the boy's mother came to know of this. She took the boy and took him to the hospital, got him treated, and a medical certificate was also obtained. Then, with the medical certificate, she went to the magistrate and filed a lodged a complaint. They cannot complain to the police because offenders are policemen. Therefore, she lodged a private complaint. The what the magistrate did was magistrate said that this is TIP is a matter during investigation. This is not a situation where investigation is in progress. Therefore, I don't have any power to conduct I'm sorry. The magistrate directed ascertained the policemen who were on duty on that day and asked 15 of them to appear before him to conduct for the purpose of a TI parade. One of the 15 policemen challenged that order before the High Court. These are the facts of a reported decision, Venugopalan versus Prakashan, 1985 KLT 615, where many of us used to feel that the High Court should not have left the boy in the lurch, because ultimately the High Court said magistrate was not exercising power during investigation. Therefore, he could not have done this. Of course, technically speaking, the learned Justice Padmanabhan, who was one of the finest judges our High Court, our state our country has produced. But Justice Padmanabhan, in fact, he took the services of amicus curiae also. And the Director General of Prosecution, Mr. M.B. Kurup, was the amicus curiae. And what happened was, the learned judge said, if the magistrate were to conduct a TI parade, he will disable himself from conducting the inquiry further, because he will be in the position of a complainant. Therefore, what actually he should have done is to inform the Chief Judicial Magistrate and requisition the services of another magistrate for conducting a TI parade. Of course, 54A was not there. But then still, it is the magistrate was not helpless. But the High Court said, because I have sympathies for the boy, but unfortunately, what the magistrate did was wrong, because magistrate could not have conducted a TI parade by himself. Therefore, in the meanwhile, the Director General of Prosecution offered that in case a complaint is given to the crime branch police, higher police officials will conduct an investigation, and there was a disciplinary action being taken against the four police constables. On recording that, the learned judge allowed the criminal 482 petition. This was a very, very tragic case. But unfortunately, this is a case where justice is a prisoner of law.
It is just like the other session we had in Letters. Presidents are supposed to do, settle law for the state or the country, not to just somehow or other settle that matter.
Justice Raviraj.
The other decision I got, it is Rana Pratap versus State of Haryana.
Rana Pratap. Correct.
AR 1983 Supreme Court
Which?
683. AR 83 Supreme Court 680.
Okay, Rana Pratap. Beautiful observation by Chinnapura.
Supreme Court 680.
83.
Beg your pardon, sir?
Citation I was posting on the chat.
83 Supreme Court 680.
AR 83.
Yeah, we have done.
680. Beautiful observations. Because you don't dub a witness as interested witness, chance witness. After all, the witness is a member of the household, etc. When the occurrence takes place inside the house, they are the natural witnesses. Likewise, clear example. When an occurrence takes place in a brothel, prostitutes and paramours are the most natural witnesses. Beautiful exposition of law. You don't dub them as unreliable or interested witnesses. With that, I think we have covered every aspect of test identification parade. We can throw the session for questions. To the best of my knowledge, ability, and capacity, I will answer the question.
Because
Yeah, I'm just checking it out as to whether any question has come on the YouTube.
you can just unmute. There is a senior public prosecutor of the High Court, Advocate Breeze.
Name.
Breeze. Breeze. I have seen him.
What I can do is I will unmute everyone, but allow everyone to be unmuted. But actually, one should only unmute himself who wants to ask a question. Otherwise, there will be a lot of buzzing.
He was my prosecutor once upon a time.
We have unmuted everyone.
Breeze.
We have allowed everyone, but anyone who wants to ask a question can unmute. Yeah.
Breeze, sir, you can unmute.
Breeze, you can put the question.
No question, Prem.
Less said the better. Is it so?
The 2047 has raised a hand. I don't know the name, but
2047, if he wants to ask a question, he can unmute.
unmute and just put the question.
2047 would be the password. That's why he would have logged through that. I will just check it out because on the YouTube we don't have. I will check it out on the Facebook. Yes, this is by Satprishi Paul on Facebook. It says for the safeguard of witnesses and victims, is it possible to make test identification parade in the virtual mode?
Virtual mode. How do you ascertain that all safeguards have been complied with? You do not know whether the person's paraded, there is any police intervention behind the person's paraded. You can't see, but there are unseen actions, unseen powers behind that. Unless you personally verify. That is why the judicial magistrate, especially the magistrates, whether executive or judicial, they are employed for doing this because they will without any fear or favor, they will do it in a foolproof and fair manner.
Sir, a question has come up whether an accused has got legal right to question the veracity of test identification parade.
Yes, he can do it during the trial. During the trial, he can say that a particular police constable had interfered, and I had made a mention to the magistrate. Magistrates either did not record that or recorded and said that it is not. That's not true. All those things can be said. He can. After all, it is only corroborative evidence, not substantive evidence. Very having very little value.
Why the right of the investigating officer to conduct test identification parade is excluded?
Is excluded. What is the question?
Why the right of identification investigating officer to conduct test identification parade is excluded is a question by Advocate Jogi.
That already answered. When the investigating officer conducts a TI parade, any act of identification, either in the form of gestures or statements, they are all done during the course of an investigation. No statement made to an officer, police officer conducting investigation under Chapter 12 can be used. That is the total embargo under Section 162, 1 CRPC. It was overlooking that in 1936, Division Bench of the Madras High Court took that view. Because act of identification is not statement. That is what the Madras High Court said. Supreme Court said no. Act of identification also amounts to a statement, which falls under Section 162.
Correct. Somebody has mentioned that there is criminal rules of practice, at least in Andhra Pradesh, which contemplates the procedure how to conduct it. Rule 32.
Yes. Every state has got a procedure. We in Kerala were following the Tamil Nadu procedure.
This is by Priyanka. Victim knows the accused persons. Still, test identification parade was conducted, but test identification parade was conducted by a senior clerk of the executive magistrate. On basis of this,
the senior clerk
executive magistrate, senior clerk of the executive magistrate. On the basis of this test, on basis of this defective test identification parade, accused was acquitted. Was a court right in acquitting, knowing that the test identification was not required at the first place?
That may not be the only evidence. That may not be the only circumstance. That may be an additional circumstance. I told you, the TI parade cannot be the sole material on which a conviction or acquittal can be recorded. It cannot form the sole basis for a conviction or acquittal.
This is by Murgusen. Whether the public prosecutor can conduct the test identification parade in his office or not due to COVID-19.
Let him try that and see the consequences.
This Anil Kumar's question, Mr. Premraj can take it.
He is a biased person. He is not. He is interested in a conviction, hook or crook, to that extent, one may say. So how can he fairly conduct a TI parade?
So that principle that nobody can be a player as well as a referee in the same match.
Exactly.
Now, another question is that in a murder case, eyewitness seen the accused for the first time while the incident happened. In this case, TIP was not done. What is the value of that witness? Already answered. Kannan versus State of Kerala.
Yes. Yes. And if during the occurrence they had sufficient exposure, sufficient interaction, then failure to conduct a TIP may not be fatal. May not be fatal. All depends on the length of the duration of the occurrence, the opportunity of the witnesses to see the accused and identify his features, etc. It all depends on that. Not merely the want or not the failure or want of TI parade. Even if the accused, the witness has previous acquaintance, there can be a valid conviction without a TI parade, provided they had sufficient exposure to the features of the accused. Yes.
So, this is accused administered oath when he appears as a defense witness?
Even when appears as a defense witness, definitely he has to be 315. You mean 315? When he is appearing as a defense witness, he has to be administered oath. He voluntarily mounts the witness box as a defense witness. So he has to be administered oath.
Raise the hand. Can you unmute and put the question?
We have allowed everyone who wants to get unmuted. Question is, but meanwhile, Ganesh says, is it the mandate to touch the accused while identifying the accused person, or identifying or pointing out from a distance? What is the requirement?
He can either say the person standing the third from the right, or fourth from the right, or second from the left, either way, or he can go near him and touch him. It's all within the discretion of the magistrate.
No.
Because the magistrate will have to record he correctly identified or he did not correctly identify. That memorandum he has to prepare. Therefore, he will have to be satisfied whether the identification is correct or not.
So this is a question RT has posted, Prakash. Can magistrate rely on a local SHO to arrange non-suspects when the test identification period is not held at jail?
Held in jail?
Yeah.
Nothing wrong. Only thing is the police will be having some bias, prejudice, etc. Because if non-suspects are not available in jail, somebody will have to be fetched. Nothing wrong. In fact, there have been cases where police were asked to secure non-suspects with similar physical things and identical features, etc. Nothing wrong. But ordinarily, They will not. They will not be asked. But nothing wrong if the investigating officer is even in the jail. The investigating officer is requested to arrange the non-suspects. Nothing wrong, because the actual act of identification takes place before the magistrate, and the police should not be allowed to have interview with the identifying witness.
Yeah. The questions are over. I will ask Mr. Sham to propose a vote of thanks. Mr. Sham?
Yeah, of course, I'm here. What else can I say? I mean,
Details.
no, not like that. It was a treat to all. It's a forensic treat, I'd say, to all the sense of satiating all our requirements as far as test identification parade is concerned. Like Ramkumar sir used to say, he is a civilized criminal or a criminal. I used to say the other way around, like basically was a criminal, but I'm civilized because I'm dealing only with civil cases. But attending his classes and knowing him at close proximity along with Premraj and the entire team, I got a fascination for nowadays, and I think I'm becoming a criminal back again. I think I don't know for the good or the worse, but either way, today the interaction was good. Questions were so formulated and articulated that all the facets and nuances of a specific area was able to be covered. This is what exactly what these webinars are meant to be. Instead of saying something so general that end of the day, everybody claps and go home and there is nothing to be taken home. But the speciality of Justice Ramkumar sir's class is that once the class is over or the session is over, you are clear about at least that facet of law that has been dealt with. That is what is required. And thank you, Vikas, for hosting this wonderful program. And thank you, Justice Ramkumar sir, for being part and parcel of this national webinar. And Prem for taking all those questions along with me. I'd like to thank each and every one of you being part of this endeavor or this I'd say the platform wherein we interact, transcending boundaries, transcending almost everything else, wherein only academics and academic pursuits matters. Thank you very much.
Yeah. So I can only thank not only the participants who are watching us live on the Facebook as well as YouTube and on this platform. And the cherry on the top of the cake would be, I will say, Mr. Premraj Menon and Sham Padman, who helped us to facilitate the reading of the questions. And as usual, Justice Ramkumar in his own style gave the answers in a very simple manner. And what, like Mr. Sham has said, that after hearing him, your facets, which or what you can say, the cobwebs in the mind, are actually that's clear. And we only hope, like what he clears the doubt, the COVID fear also is cleared in the same manner. And thank you, friends, for connecting us. And we are all thankful to Justice Ramkumar, who always helps us to improve our knowledge in his own style. And words fall short, the manner in which he explains. Thank you, everyone. Stay safe, stay blessed. And namaskar. And tomorrow we will connect a very simple topic, because a lot of people said that since we are preparing for the judicial exams, how one has to do effective English communication. So do stay connected with us.